Okay, guys, we are now finishing up chapter 5 and chapter 6 is the purple packet that we have now. We have finished the red. We are now starting on the purple packet. I will do some questions towards the middle. I want to kind of do the chapter 5 as a refresher and chapter 6 as a beginning. But if you weren't here for the part 1, we finished off with business intentional torts, and we are now on property intentional torts on page 123 of your study guide. 123 of your study guide. All right. Property intentional torts still fall under intentional torts, which is you meant to do the act resulted in harm to another. All right, real property. Real property is best defined as land or anything permanently attached to the land. That would include trees, a house, a barn, stuff like that, driveway, anything like that. And I say driveway for potential questions later on. Anything else not pertaining to land or permanently attached to the land is called personal property. That would include vehicles, clothes, knickknacks, antiques, anything like that. So if someone was to come onto your property to steal items in your home, that would be a trespass to real property because they came on your land. And if they stole it, that'd be a trespass to personal property, i.e. conversion as well, for the stealing of the items in your land or on your land. All right, so when we talk about real property and personal property can be either tangible, meaning something you can touch, that would be vehicle, clothes, stuff like that, or something intangible. Stocks, bonds, that would be chapter 9, 10 for your next exam, and or intellectual property would fall into this as well. So intangible personal property would also be intellectual property, which we'll get to in about 20 minutes or so. All right, trespass to property. Trespass to real property, trespass to land, trespass is any unauthorized action, physical intrusion upon or entry upon land where someone else has a superior right to that property. Now, if you're the owner of the land, you have a superior right to the property. If you are leasing that land from someone else, you have a superior right to that property as well. And if someone comes on your land without permission, then it's considered to be a trespass. Now, a landlord has options to come on the land, but we're not going to get into that. I haven't heard about him doing that stuff. Now, an element for trespass to real property is a person who enters on, above, or below the surface of the land, or allows anything without permission, allows anything to stay on, above, or below the surface of the land, or remain off on the land after being told to leave. Now, the on, above, or below simply means, something that would be in the immediate vicinity, like aircraft carriers and aircraft wouldn't count. Not aircraft carriers, but aircraft wouldn't count. But anything like staying slightly above your property or below the surface of your property, maybe a storage shed or a basement or something like that, would not be allowed as well. No harm to the land is necessary. Just being on the land is considered to be a trespass if you don't have permission to do so. Now, most people will not, worry about a trespasser being on their land unless something's going to happen to the land. But for test purposes, no harm to the land is necessary. Okay? Anything remaining on, above, or below the surface of the land after taking permission being taken away or permission was never granted would likely be considered to be a trespass to real property, trespass to land, or just simply trespass, depending on how he phrases it on the exam. Now, the owner, in some way, shape, or form, must notify that person that they are a trespasser. This can be done through words. This could be done through a sign saying no trespassing sign. Or if you look on the next page of the study guide on page 124, if you tell people leave and they won't leave, no trespassing sign. But then you also have this purplish lavender paint markings under the Texas Penal Code. Those I don't think you're going to know exactly how many feet apart or something like that. But if you get a question on purple lavenderish, that is dealing with trespass and being told that you are not allowed to be on this land. So if you see these paint markings in a purple lavender situation, then you're probably not going to be allowed on that land, or you would be considered to be a trespasser. The other thing that we need to talk about is if you're a thief. If you come on the land to steal something, either inside a house, inside a car, garage, or anything like that, then if you go through a closed door or window or something like that, you are considered to be a trespasser. It's automatically assumed implicitly that a thief would be considered to be a trespasser. Now, the question becomes, if someone is trespassing who is usually responsible for any damages and or injuries that the trespasser causes or could happen to them if they're on the land? And the answer is the owner is generally not liable for any trespasser's damages and or injuries that a trespasser sustains. So if someone without permission or if permission has been taken away, say you were invited to a party, you don't show, you show up, you do something that they ask you to leave. We'll talk about how they can ask you to leave, reasonable force, all that stuff in a bit. But if you don't leave, then you're considered to be a trespasser. Any damages associated to what you do, whether you break something inside the house, whether you injure yourself while on the land, then you ultimately as a trespasser are likely liable for those actions. Now, that is the one thing. Now, there are two situations in which ownership or the owner would likely be more liable rather than the trespasser. One is a reasonable duty. Reasonable duty is usually not in Texas. We don't use it in Texas, but just simply saying that if there's a bad dog or something like that and you're trying to get away from it, or the owner knows of a danger and discloses that, then there's a reasonable duty that if something happens that the owner would be held liable. And that's like if there's a dog or something like that that bit you as you crossed over into land. If they knew that dog was going to be vicious, they may be held responsible. Now, the one that's usually on the exam and the one that's in Texas is called the attractive nuisance doctrine. Now, the attractive nuisance doctrine applies to young children. Now, how does he say that on the exam? He may give you a storyline and give you an age. If you're, say, 5 or 6 years old, you don't understand the nature and consequences of your actions when you enter on someone's land. So now, who is liability for damages and or injury go with? And typically with the attractive nuisance doctrine, the owner is going to be held liable for that situation. The owner is going to be held liable if a young child comes onto the land. Now, what would attract, i.e. the attractive nuisance doctrine, what would attract a young child onto the land? And that'd be anything that a young child would be interested in. Swimming pool, whether it's with or without water. Kids with skateboards would love that. Water, obviously, if you want to swim. Trampolines, swing sets. In the book, in the study guide, it has abandoned refrigerator. All of those are things that would entice a kid to want to come onto the land. And say a kid sees your trampoline, cuts through a fence, or goes over a fence, jumps on it and falls and breaks their arm. Who is typically going to be held responsible? Well, that would likely be the owner would be held responsible. And if you buy a house, typically when you get homeowners insurance, the insurance agent will likely ask you, do you have a trampoline? Do you have a swing set? Do you have a pool? The reason is they're building in insurance for this attractive nuisance doctrine because kids are going to come on the land. So they want to know if they're going to be held for more liability for a possible kid that comes on the land. Now, if you get a question, say the kid's 17, 18 years old, then they understand the nature and consequences of their actions. And if they fall while jumping in a pool or playing on a swing set, maybe drunk or something like that, they are not considered to be a young child. Attractive nuisance wouldn't apply to them, and therefore they would be held liable for any damages as a result to the actual land itself and or damages to themselves, and we wouldn't have to worry about the owner being held liable. Now, the one quick question on attractive nuisance that he has is, he'll just simply ask, which of the following situations would likely the attractive nuisance doctrine apply? And he'll give you a bunch of different situations. And that's where you just simply have to ask yourself, if given a storyline, would a young kid be enticed to come on that land? Swimming pool, abandoned refrigerator, swing set, trampoline, pool without water. All those things come into play. Now, the hot blonde next door, that's just attractive. And I joke around, but that is true, because that might be one of your options that doesn't fall under the thing, because that's not, other than attractive, that's not a nuisance, okay? Now, when an owner finds someone trespassing on their land, where it's the purple lavender markings, whether it's a thief, whatever reason they ask a person to leave and they haven't left yet, then they can use reasonable force to move that person off their land. Now, that land extends from the house all the way to the end of their property. So if an owner wants to remove a trespasser, they can use reasonable force. Now, once again, we have to go back to what is reasonable force. The average person, reasonable person of ordinary prudence, to determine what is going to be reasonable. If you're using reasonable force to remove a trespasser and they decide to sue you, okay, then they are the plaintiff, you are the tortfeasor defendant, you are going to be able to defend yourself so long as you use reasonable force to remove a trespasser if they were known to be a trespasser. If you just get mad at them and don't say a word to them and then just try to remove them, then they might not consider themselves a trespasser. If you tell them you're trespassing, you need to leave, and they don't do it, then reasonable force can be done. If they decide they want to sue you for assault, battery, you would be able to likely defend yourself as long as it wasn't unreasonable, but rather reasonable. And that's what you need to look at for answer A, answer B, A and B on the exam. Was the force that was used reasonable? Deadly force would not be able to be used in that situation more than likely. All right, defenses to trespass. A trespasser can come onto your land to assist someone in danger, regardless if that person is a trespasser as well. And he might have one of those multiple choice options where on, like, say, answer choice B or answer choice C, he'll say, Barney goes onto the land to help Robin, who is in danger. Even if Robin is a trespasser, Barney is allowed to go on. That is one of the defenses. That is true. Okay? If you get a multiple choice answer that says Barney would then be a trespasser if he's helping Robin who is trespassing, no. Robin would be a trespasser. That is true. Barney would not. Barney would have a successful defense. If you enter to protect your property, a trespasser comes onto your land to protect property, whatever the property is. Say they have something on your land and they're worried about it being stolen or taken, they can come on your land to enter to protect property, their property specifically. The non-defenses is if they go on the land to improve the property, they don't have a right to do so. That's not going to be viable. Or if I thought it was allowed, I didn't know it wasn't, I thought it was allowed. Those are not viable defenses. To remove a trespasser, you have reasonable force. If a trespasser comes on your land, they are a trespasser. A person can come onto land to help assist that trespasser or assist someone who is in danger, regardless if they are a trespasser or not, and they would not be considered to be a trespasser as well. All right. Now, the next one we have is trespass to personal property. Now, trespass to personal property is, remember, personal property is anything that's non-land, i.e. clothing, vehicles. It could be tangible or intangible. It is basically the harming or the interfering with someone, personal property owner's rights to exclusive possession and or enjoyment of that property. Okay? It's when you meddle, when you cause problems with someone else's property. So say you have a car in your driveway on your land. Someone comes on the land and slits the tires and smashes the windshield to your car. What do you have a possibility of? Well, they entered on the land probably without permission, because you probably didn't grant permission for someone to do that. So they had trespassed to real property to come on your land. Then they also trespassed to personal property by damaging or taking away your enjoyment and exclusive possession and enjoyment of your private property, the vehicle in this case, slitting the tires, smashing the windshield, whatever it is, key scratching the car, all examples there that would come into play. When that happens, then not only do you have trespass to real property, but you also have trespass to personal property. Okay? The thing about trespass to personal property versus conversion, conversion is basically the crime of theft. The taking of something is a tort of conversion. The tort of conversion is the wrongful taking of property of another that places the property in the service of the trespasser. Now, this falls under the guidelines of trespass to personal property. So it's basically a sub-element of it. So if you're given an answer and the answer you think is conversion, and then one of the other choices is trespass to personal property, and one of the other answers is conversion and trespass to personal property, if you know it's conversion, you probably need to go with both of the answers. If you know it's just trespass to personal property and not conversion, then you probably just go with trespass to personal property. Let me give you an example of this. If I key scratch your car, if I slit your tires, if I smash your windshield on your land, that is trespass to real property for coming on your land without permission, trespass to personal property because I left it in a damaged state, took away your enjoyment of it. If I actually came on your land and stole the car, then it would be trespass to real property because the thief is implicit, considered to be a trespasser. And then that would be conversion because now I've stolen your property and taken it away from you. Now, by taking it away from you, have I taken away your use and enjoyment of your private property? Absolutely. So that conversion would also lead to a trespass to personal property as well. So now we have a bunch of different situations. Where that car is, what happens to that car can be a bunch of different multiple choice answers. If on Form A in the exam, and I don't know if there's going to be a bunch of forms that are being online this test round, but if there are a bunch of different forms, Form A could say the car is on your property, in your driveway, in your garage. You key scratch the car, you slit the tires, you sledgehammer the windshield, but you leave it there. What happened? You have trespassed to real property, trespassed to personal property, but no conversion. The car's in the street in front of your home. You don't enter into the yard itself, then we have no trespass to real property. But if you slid the tires, key scratch the car's windshield damage, then we have trespass to personal property, correct? If the car is in the driveway and you steal it, trespass to real property, conversion, trespass to personal property, because that's conversion is a sub-element to trespass to personal property. But if the car is in the front of the house, in the street, then that is going to be conversion or trespass to personal property, but not trespass to real property. So you have a bunch of different things on where that car is located, what you do to the car, what you do with the car that could make any of the trespass situations come into play. Recognize this. The good rule of thumb is trespass to real property involves getting on the land, on, above, or below the surface land, but on the land or anything derived to the land. Trespass to personal property, damaging it. Conversion, a form of trespass to personal property, is the stealing of it. If you can go with that, you're in good shape for test purposes as well. Okay? All right. In terms of equitable versus monetary damages, monetary damage would be monetary to support the tortfeasor to pay for any property that was damaged. So say they damaged the car, you'd have to pay the monetary damages to fix it. Equitable damage, if they took the car, they would have to return it. And then you might want to do something else as well, but they'd have to return the car. All right. Non-defenses towards conversion is buying stolen goods, good intentions or a mistake. Those are not viable defenses. But taking a rabid animal for testing if you got bit, that could be a successful defense. And that is on the middle of page 125. I would note F and G is just one little thing on middle of 125 in terms of what is and what is not allowed to take of someone's property. And we're talking conversion, taking of the property. I would note those in case he gives you a storyline question there. Now, at the bottom of page 125 is nuisance. Nuisance also falls under this idea of land. It is any conduct which interferes with enjoyment or use of the land. And then you'll look at C, kind of right below that, must be an unreasonable interference. So if you combine those terms, the best definition of nuisance is an unreasonable interference conduct, which is an unreasonable interference with the use or enjoyment of someone's land. Okay. Now, what could this be? This could be noise, way beyond what normal people have to deal with. This could be lighting. It could be smells. Anything could fall under nuisance. Okay. For instance, if your neighbor is getting their roof redone, and during the middle of July, there are roofers during the day on top of that roof hammering away, that is not an unreasonable interference with the use or enjoyment of your land next door. Even though it may interfere with your enjoyment of it, it's not unreasonable. People are expected to change the roofs every once in a while, especially after some damage to them. Now, if those same roofers in July decided, hey, here's what we're going to do. We're going to get up and go at 4 a.m., put on some strobe lights, and hammer at 4 a.m. next door to you, and those strobe lights entered into your bedroom to where you couldn't sleep, that would likely be an unreasonable interference with your land. Therefore, that could be a nuisance. Now, would that be a public nuisance or a private nuisance? A public nuisance affects a large group of people, the public as a whole. Private nuisance affects one or a few people. That would be an example of a private nuisance. So if you put on a strobe light, and because of that strobe light, you couldn't sleep, or say that strobe light comes on and the roofers can see into your bedroom where they normally couldn't, and they see you doing certain activities, and they watch you and videotape you, then that could be an invasion of privacy based upon that as well, because you had a reasonable expectation to the privacy. And that's just going back to the personal intentional torts that we talked about in the red packet. All right, so nuisance, unreasonable interference with the use or enjoyment of your land. What if you invite me to your party, and after making some really rude jokes, I start farting uncontrollably? You asked me to leave. Well, one, you could say trespass to real property because you asked me to leave and I didn't leave. You could use reasonable force to remove me, the trespasser. Assault and battery, if I sued you for it, you'd probably be protected from that. Okay? But then you could also sue me for nuisance. Because if I'm farting uncontrollably, if I'm shouting loud obscenities in your front yard, I'm still on your land, so you still got trespass. If I go into the street and shout obscenities or say certain things, then nuisance, because that's an unreasonable interference with the use or enjoyment of your land. If I say things that are false while on the street, that could be a nuisance. That could have been a trespass before, and now I'm on the street. Okay? But then if I'm making false statements, that could be defamation of character. So you have a bunch of different ways a storyline can go that you could go from that same storyline to one thing about nuisance, followed by trespass, then maybe followed by defamation of character or invasion of privacy. Okay? Nuisance is an unreasonable interference with the use or enjoyment of your land. It affects a public as a whole, a large group of people, that would be a public nuisance. A small group of people, like a neighborhood or something like that, that'd be a private nuisance. So what if we had a noise ordinance and in the Woodlands it said a concert at the Woodlands Amphitheater could not extend past 11:30 at night? And during a concert, the guys are like, we're going to play all night long. And they actually do for quite a while. And 1:30 in the morning, it's still loud in front of in that neighborhood to the point where all the neighbors are affected. That would probably be a public nuisance. If an airport was to decide to expand, that might be a public nuisance because now you're going to get larger aircraft in there as well. You might have a problem there with public nuisance. If you bought that land and the airport next to it is already the size of, say, DFW Airport, you can't then say, oh, public nuisance land, that's a public nuisance because of the noise of the aircraft, because you already knew it was there when you bought the property. Okay? Must be an unreasonable interference. All right, that is on page 125. Now we are on page 126 of your study guide, and we are talking about intellectual property. Now, in your purple packet, there is a page called Intellectual Property Information. I'm not sure if you can see it with the video. It's not that great. It's about the third or fourth page in the packet. It's a 2-page synopsis of intellectual property. Okay? Most of the stuff that you're going to need to know about intellectual property is here. We'll go over a few that you don't need to know, a couple of terms that you might want to know, and then we're going to put together a little log sheet on terms and durations and stuff like that that will help you with intellectual property. Now, there's also a group of 30 questions in the purple packet just on intellectual property alone. If it is a big thing on your exam, you're probably going to have maybe 4 or 5 questions on it. It's not going to be a huge, like 40% of the exam. It's probably going to be about 10% of your exam if you get a large amount of it on the exam. Now, when we talk about intellectual property, that is property created from the ideas or thoughts, processes of the creator. There are 3 major types, and then there's a couple of them that fall as a sub-element, but could be, if he gives you an A, B, C, D, and E, are likely going to be answers that are available. Unless it's specific to that kind of a question, those are probably not going to be the right answers. But the 3 main types are copyrights, patents, and trademarks. Also, service marks fall under trademarks depending on what they do. All right, copyrights and patents are exclusively federally protected. If you get a multiple choice answer in which state law, state patent law, or state copyright law comes into play, those are not viable answers, because everything dealing with copyright infringement and patent infringement is going to be done at the federal level. It's exclusively federal. It's constitutionally protected under constitutional law, enumerated powers, all that stuff. Okay? Trademarks are also federally protected, but are not exclusively federal, because anything that doesn't fall under the federal protection under trademark law could be under state law, depending on what states can offer. So if something does not fall under federal law for trademarks, states could protect it as well. So which of the following is federally protected form of intellectual property? Copyrights, patents, and trademarks are all excellent examples. Which of the following are exclusively federally protected? Only copyrights and patents. Trademarks wouldn't be an option. Which of the following is state protected as well as federal? Trademark law. Okay, of the big 3. Now you got trade names, trade secrets. It falls kind of under trademark law as well. All right, the first one is copyrights. Exclusively to the national government. There's no state involvement in copyright law. Copyright Act of 1790 created that. Now, On page 127 of your study guide, it talks about the author given exclusive rights to reproduce the work, create the work, distribute copies, perform the work, not perform the work, display in public, all those things. And then gives you a list at the bottom of page one, midway, all the rest of the page 127, what it covers. And it gives you like 14 different things it covers. If you're one of those persons that like to memorize, you can memorize that, but just read it over, kind of think about it through, and just say, oh, copyright would cover that. Okay? Anything that's going to be work-related, literary, or fictional, or non-fictional would probably fall into that. So workers' manuals would be copyrighted probably. If it's a worker's manual to a machine, the machine is probably patent law, but copyright would cover the worker's manual. Okay? Now, the one thing that a lot of people get wrong on the exam is towards the very bottom of page 127, when it talks about radio and television. The dramas, the comedies, the documentaries are all going to be covered under copyright law. I think that's self-explanatory because it's something created by the copyright holder. They have exclusive rights to it. It's kind of like music and TV and stuff like that. But the one right below it is news reporting. Towards the very bottom of page 127, news reporting. News reporting is copyrighted. The actual news event itself is not. So say about the coronavirus or 9/11 or something like that. That event, that situation is not copyrighted material. But how ABC, NBC, Fox News, Fox, ESPN handle their reporting of the coronavirus or 9/11 or whatever would actually be copyrighted because it's the way they told their story in real time. Okay? What else is not covered is historical information, scientific information, ideas, processes, inventions, factual information, and then trademarks. Well, think about it this way. Of those things that are not copyrighted, ideas, processes, inventions, number 4, 5, and 6 on page 128, all fall under patent law. That's why it's not copyrighted, it's patent. Trademarks, not under copyright law because it's under trademark law. The other ones, no specific person has ownership of historical information, factual information, scientific information necessarily. They don't have exclusive rights to it. And since there's no one with exclusive rights on copyright, it's not going to be able to be copyrighted. Okay? Now, if you put a C with a circle around it, what you're saying is that is my property. I own it. Okay? It doesn't mean you file with the U.S. Copyright Office. It doesn't mean that what you're saying is I own it. This is the date, my name, this is what I did. I can guarantee you, and maybe not on this exam, but on the first exam, you probably had a cover page on your exam with swim and had a bunch of details on instructions and stuff like that. And you probably put at the very bottom, copyright infringement with a C with a circle around it, key swim in the year, to basically say, these are my questions, I own these. Because if someone steals those questions and uses them, and we'll get to that a little bit later on, but if someone steals them, he has copyright protection on those. Does that mean he files the exam to the U.S. Copyright Office? No, he's just saying, I own these. C with a circle around it. Okay? Now, the Copyright Act of 1978 gives automatic rights to works created after 1978. I'm sorry, 1976 gives automatic right to things after 1978. Now, if we go on page 129 of your study guide, here's the thing. What happens if you register your material, your copyrighted material, with the U.S. Copyright Office versus if you just put a C with a circle around it, that's all you do? Well, the thing is, you get added benefits if you have filed with the U.S. Copyright Office, but you still get possibility of remedies against anybody who infringes or takes away your copyright, even if you don't file. For example, say for instance, someone was to take this packet that I've made up and it has a little C with a circle around it at the very bottom and basically all the copyright information at the very bottom. If someone was to take this copy and send it out in a mass email, I could theoretically say you did that without permission, either electronic or otherwise, you did that without permission. And all I have to do is show that you have the capability of getting a packet. And then I would say, okay, you did that. I can charge you a fee. I can impound all pirated copies. I can get an injunction to stop it before it happens. I can get damages. Okay? I can get these with or without filing with the U.S. Copyright Office. This is not filed with the U.S. Copyright Office. But if I didn't file it, I can still get an injunction stopping you from doing it. I can still impound pirated copies if you made a bunch of copies, or I can impound the things that go through a GroupMe or stuff like that. But what the main thing I can do is I can get actual damages. Okay, I can get actual damages, and if the packet is worth $35 a person, and you send it out to 500 people, I can charge you 500 times $35 per person. That's a big chunk of change, because that would be actual damages that I suffered because someone didn't buy it that could have bought it, or you gave something of $35 of value. So I could impound the pirated copies, I could get an injunction stopping you, or I could go after damages in terms of actual damages. Now, other things I could get, maybe attorney's fees and or statutory damages under federal law as well. The problem with that statutory damages and attorney's fees, if I haven't registered with the U.S. Copyright Office, these are typically not available to me. So here's how the question comes on page 129 of the study guide. It gives you a little scenario, and in one form it says you have filed. In another form, you have not filed. What possible remedies can this person get on Form A versus this person can get on Form B? If you have filed, you can pretty much get everything. You can get statutory damages, you can get actual damages, you can get attorney's fees, you can impound pirated copies, which would be an equitable relief form. You can get an injunction to stop an action before it causes irreparable harm. All of those are available to you. However, if you have not filed, you can still get the injunction, you can still impound pirated copies, and you can still get damages, actual damages. But you would not be able to get attorney's fees and or statutory damages. So there is a benefit if you think someone's going to steal it to file with the U.S. Copyright Office, because attorney's fees can be rather expensive. All right. If I'm going to worry about approving of a copyright infringement, all I have to do is show that you have the capability of getting to this packet and doing whatever you did with it. If you bought it from me, that's pretty easy to prove that you have the capability of doing it. All right. The next thing starts on bottom of page 129 of your study guide and is usually on the exam. It is a Sonny Bono Copyright Extension Act of 1998. Now, you're going to need to know the formal name. That is a formal name, Sonny Bono Copyright Extension Act of 1998. And you also need to know the informal name. That could be the Mickey Mouse Act and or the Disney Act. Either one would apply. Okay? And this basically says how long a copyright has in terms of duration. And the duration under the Sonny Bono Copyright Extension Act, and you will need to know formal and informal name, not only for this exam, but also probably for the comprehensive final, all right, is how long does this extension last? The extension lasts the author's lifetime, however long the author is alive, plus 70 years. Okay, in addition to the author's lifetime, plus 70 years. Now, for the publisher, it's a set date. It's 95 years from the date of publication, or 120 years from the date of creation, whichever comes first. The only way that the 120 years comes into play if there's more than a 25-year gap between the creation of the copyrighted material and its actually publication. If there's less than a 25-year gap, then the 95 years will come first. Okay? That's just in terms of a storyline scenario. Now, if he gives you a question and says, how long does the author have exclusive copyright, exclusive holding over this material, this copyrighted material? Say it's a book. The characters in the books, the written words in the books and stuff like that, all that stuff and how the theme was and everything like that, they have an exclusive right of that for the author's lifetime plus 70 years. So if he gives you a question on the exam, and in the question on the exam, the author is not dead, you cannot determine an exact year when the copyright will end. You won't be able to do it. If the author is dead, you can figure it out just by adding 70 years from the author's death. Forget when it gets published. Forget when it gets written if we're talking about the author. Those are irrelevant. Is the author alive or dead? If the author is alive, you don't have a specific number. You just know it's going to be at least 70 more years from this date, because they could die tomorrow. Okay? But if the author is dead, you just add 70 years from the year they died. So if they died in 2000, then the author's heirs, their family, has the rights till 2070, 70 years after. If it's now 2020, and the author hadn't died yet, you know it'll be at least until 2090. At least until 2090. That might be the best answer multiple choice wise. At least until 2090, until that copyright will not be applied to the author. But until they die, you don't have a specific number. Now, if it gives you when it was created and all that stuff, and then the author hasn't died, but he asks you how long the publisher has, then you know a specific number. Whatever the publication date is, you look at that and add 95 years to it. If the publication was 30 years after it was actually created, then you're going to go 120 years from the date of creation if you know the date of creation. So say a book is created in 1970, but it's not actually published until 2000. So there's a 30-year gap. Well, if you go 120 years from 1970, that's 2090. If you went from the year it was published, 2000, 95 years, 2095, which occurred first? 2090 occurred first. Therefore, that would be the answer for how long the publisher has the rights to the book. Okay? So note that for the exam purposes. Okay? Disney Act, Mickey Mouse Act is the informal name to the Sonny Bono Copyright Extension Act. Now, within that Copyright Extension Act, we also have a couple of terms on page 130 that you need to know as well, and that is compulsory licensing. When we talk about compulsory licensing, this is where a copyright holder must grant permission for someone else to use the work once it has been distributed to the public. Now, they are still entitled to control over manner and method, melody, fundamental rearrangements, and stuff like that. But more importantly, they're going to be entitled to royalty payments. Okay? If the person doesn't use it, they could lose their license and all that stuff. But think about it this way. So say you wrote a song and you have exclusive rights to that song for a period of whatever. But once you perform it in public, other people can do it as well. So take the band Weezer. They pretty much do a cover of everything nowadays. If Weezer was to take a band song and then do their own cover on it, would they be allowed under compulsory licensing? Probably so. Now, would the original copyright holder of that song be able to control the manner and method in which Weezer does it? Yes. Would they be entitled to royalty payments from the sales or whatever Weezer gets for using that song? Absolutely. And that's probably the main thing they're going to want to go for is royalty payments. They're going to be able to do those things. Compulsory licensing is where you must grant permission for someone to use the work after you've been distributed to the public, use the work in public. You're more than likely going to get control over manner and method, but more importantly, you're going to be entitled to royalty payments. Okay? So note that. And there's examples of royalty licensing agreements with BMI. We'll talk about BMI in chapter 7 on your third exam, or no, on this exam, but in chapter 7, antitrust law. The other thing that we need to talk about with copyright is the fair use doctrine. In the fair use doctrine, the four-pronged test for the use of the fair use doctrine is nonprofit educational use. So say I took this exam of SWIMS once again, okay? I took this exam of SWIMS and I copied off the last, say, 5 questions. Maybe I changed the name. Instead of it being Sally and Greg, I changed it to Robin and Barney like I always do with my How I Met Your Mother characters. But I changed up the thing, but the same questions, the multiple choice answers are the same. Maybe I inverted C and B, you know, but for the most part, I basically stole SWIM's question. But I only stole a few of them, say the last 5 questions, and I put it in the packet as, say, the first 5 of the questions in here. Could SWIM sue? And if he did, who would win and why? Well, could I argue fair use doctrine? I could say, hey, I'm doing this for educational use. I'm only using a small percentage of the total work used. I'm only doing 5 of the 50 or 55 questions that are available. So it's a small percentage of the work used. I even changed it up a little bit, so I made it my own thing. Those are not going to apply because, one, for fair use doctrine to apply, it's got to be educational use. Okay, we can argue educational use, nonprofit educational use. That doesn't work. Number 2 is missing. Okay, so I would not be able to. He could sue me for copyright infringement and go after royalty payments, whatever I do, whatever he wants to do in terms of that. Okay, so the things under copyright that you need to know for the test is compulsory licensing and fair use doctrine and when they can and cannot be used, the Sonny Bono Copyright Extension Act, the author's lifetime, publishers, and stuff like that. And you need to know duration, 70 years, 95 years, 120 years, what that comes into play. And remember, it's life plus 70, not just 70. A lot of people just add 70 years from the year they were born or something like that. Year you were born is irrelevant except to your family, okay? So the next thing we have is internet problems associated with copyright. Copyright is protected on the internet. Of course, problem is it's going to be difficult to enforce because technology is getting bigger. China and Eastern European countries don't really subscribe to bilateral treaties or the Berne Convention when it comes to intellectual property and copyright infringement. So the problem is the country just allows it to happen. But if it happens in the United States, you know at least you have recourse. And you have bilateral treaties in the Berne Convention internationally, but it's much more difficult to deal with. All right, we're going to do one more. We're going to do patent law, and then we'll take a little break. But patent law on page 131. Patent law is exclusively federally protected, okay? It is a grant from the federal government for the applicant to have the right to make, use, or sell, or allow others the right to make, use, or sell, or modify, or what? An invention. An invention, we're talking about, when we talk about patent law, we're talking about inventions, manufacturing processes, designs, automated systems, and stuff like that that fall under patent. Now, patent law is not automatically given. You must file for it. You must ask for it. You must be granted it. It is expensive. You usually need an agent and or a lawyer that's going to help you through the process. And you're going to have to file with the U.S. Patent and Trademark Office in order for it to be a valid patent in the eyes of law. Okay? It's expensive, difficult to do. And on page 132 of your study guide, it says who can register, who should file, and stuff like that. Provisional filing and whatnot. How long does a how long does a patent last? A patent will last 20 years. Now, the duration and when it starts, that's up for debate. Generally, the patent, once you apply for the patent, that starts the 20-year process because at least you've started up with the patent infringement, and then if you're filing at least until you get it. But sometimes, depending on what it is, if it's a long, drawn-out process, they'll wait till you actually get the patent given to you to start the 20 years. So sometimes a patent term will last 20 years from the beginning of the process that you start. Sometimes if it's a elongated period or it's specific, it may start when you actually get the patent from the U.S. Copyright and Patent and Trademark Office. Okay. Now, when you're doing this, there is a 20-year right to exclude others. So if you come up with an invention, you have a 20-year right to exclude others from using it, from modifying it, do whatever you want for it. So it gives the government, the federal government, remember this is exclusively federal, gives you basically a 20-year monopoly on all this information, okay? After you've done it, and after that 20 years expires, you typically cannot renew it. Only by congressional act or something like that can you renew it. So typically it only lasts a duration of 20 years, not to be extended, not renewable. Okay, so a patent typically lasts only 20 years, but during that 20 years, you can get quite a bit. Say you're one of these people that created some online poker or poker on TV, and you did the lipstick cameras inside the thing, and you did all this customized TV poker playing. For those cameras inside poker tables, you might have a 20-year right to exclude others from doing that because you have a patent on it. Or if others want to use it, they're going to have to pay you royalty payments to do so. Now, if someone infringes within that 20 years on your patent, okay, by making or using or selling or allowing others to make or use without your permission, okay, you have to go to the state in which the infringement occurred and go to the district court, U.S. district, it's all federal, U.S. district court in the state that it occurred in. So if I create a patent, get it filed, get everything gone through, and now I've got a 20-year right, and say my neighbor steals the idea, modifies it without my permission, and then does it on his own and steals my patent or uses my patent without my permission. Since he lives next to me, I'm going to go to the Southern District Court of Texas because that is where the infringement occurred, and the district court would be in Texas, and we're in the Southern District if you remember exam 1. So I would do that. If the infringement occurred in Indiana, I would go to their district court in Indiana. Now, if it's foreign, I've got to likely go to the country in which it occurred for relief. I'm not going to go to the United States. Patent lawsuits are private. The government doesn't involve themselves in them. You have to file. Okay. If it gets appealed, it goes to the Federal Court of Appeals in Washington, D.C. Remember, we have that circuit court dealing with intellectual property. That's where it is in D.C. All right. So we have a 20-year right to exclude others on that patent. After the patent expires for 20 years, the patent is not worthless, but it is non-renewable, and now others can do it. So say you patent a drug, and drug had FDA approval. During the first few years of that 20 years, you're going to be able to charge an arm and a leg for that pill because no one else has a right to do so. You've got a patent on it. But once that 20 years comes up, then a generic equivalent can probably be made by a bunch of different chemical companies, biological companies, and stuff like that. Biotechnical companies. Anybody could make that pill because now you don't have an exclusive right to it because it expired after 20 years. And now they can do it for whatever price. That's why we can get generic products for cheaper sometimes because the patent has expired. Okay? So note that patent law, 20 years right. Depending on when you apply for it and all that stuff, the 20 years could start immediately or when the actual patent is given to you. Once again, infringement, you go to the district where the infringement occurred to get damages, and you can go for damages or an injunction, which would be your equitable relief. And then if it's foreign, you have to go to the country for relief as well. You can't go in the United States for it. You've got to go foreign. All right. So now we have a 20-year right to exclude others. Okay, we are on page 134 dealing with trademark service marks. We're going to take a quick break. We're going on to the next video. Trademarks will be where we leave off in the middle of page 134.